Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about deliberative secrecy with administrative tribunals. Cases that should have gone to the Supreme Court of Canada, but didn't. Administrative tribunals, just like judges, have a right to deliberative secrecy. The mechanism used to ultimately come to the reasons for judgment doesn't have to be revealed. The judge's notes, the adjudicator's working documents don't have to be revealed to a person who's challenging their decision. But when it comes to administrative tribunals, these decisions can have a much broader impact than just the individual case. And so an assessment of the rules of deliberative secrecy when they apply to something that is not fully judicial but quasi-judicial might be appropriate. This is particularly so because administrative tribunals aren't necessarily always recorded, and so records of the proceedings themselves don't always exist or necessarily exist, such that the tribunal members' notes and deliberative documents may actually form the basis of a determination if there's a dispute about what arguments were raised or how they were characterized or what was said. And similarly, in administrative proceedings, the standards for reasons are not as high as the standards for reasons for judges. And so imperfection is often overlooked. But if there's a problem with imperfection that actually leads to an analysis of an issue that wasn't what was argued before the tribunal, or a failure to address an issue that was argued before the tribunal that may have changed the outcome, these are things that would warrant piercing that veil of deliberative secrecy. And yet, unless the tribunal consents to it, there really is no good mechanism to ensure that this is happening. The Supreme Court of Canada had an opportunity in this case to hear the issue of deliberative secrecy when it comes to this sort of lower level of justice that we have that's different from courts, that's different from the deliberative secrecy that you might have with government documents. And unfortunately, I think they missed the mark in not allowing leave to a case that really got at the issue, the heart of the issue of why deliberative secrecy is less important when it comes to administrative tribunals than it would be in these other significant and important contexts. Hopefully, the Supreme Court of Canada has the opportunity to consider this issue again, because if administrative justice is going to occur in Canada, it must happen in a way that ensures administrative fairness. And right now, with these rules with respect to deliberative secrecy, that may not always be the case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.